our next topic is on employment law, and hopefully all of our business owners out there will be, if you don't already have employees, will be hiring employees, creating jobs in the near future. So it's an important topic. And so the title of the presentation is Considerations when Hiring Your First Employee, and the speaker is Mike Coles. A little bit about Mike. Mike has his own firm, the Coles Firm. He draws on nearly 20 years of legal experience to identify and solve the challenges that confront his clients. He's a transactional lawyer, a litigator, mediator, business owner, and entrepreneur, and uses this experience to help clients identify and achieve their goals. Mike has presented cases to judges, juries, governmental agencies, and arbitrators in 20 states at hearings, trials, and appeals in state and federal courts. He is a graduate of Duke Law School. With that, I'll turn it over to Mike.
So, as Justin said, my name is Mike Coles of the Coles Firm, and what I'm going to talk to you about today is hiring your first employee. And if you already have employees, certainly you can look through this and figure out, did I do it correctly? Is there anything that I missed? And if you are thinking of hiring someone, certainly this is a good way to kind of check your work as you go through that experience. As we're talking, I certainly will look for questions in the Q&A and try to answer them in the course of the conversation rather than wait till the end. But of course, if you've got questions that I miss, or perhaps you didn't think of it until later, I'll come back and loop back and figure out how to get those questions answered as well. So let's dive right in. We've got 4 topics to cover, and we've got an hour before you're going to try to get some lunch. So we're going to make some progress here. The first question to address is, do I actually have an employee? Many times I get clients that come to me and they're trying to put together some kind of structure to bring a new person on board. And the first question that I want them to think about is this an employee or is it a contractor? A lot of times my clients prefer contractor basis for a host of reasons, which are probably obvious, but I'll cover them very briefly, which is contractors have a tax advantage that you can, in fact, avoid paying your side of the employee tax. There's also the option of dealing with overtime through this method. It's really a difficult process to be able to put someone into an independent contractor status in a lot of cases. It's easy on paper, but let's talk about what that really looks like. The reality is that there are a couple of different tests that are used. There's the 5-factor test, the 20-factor test, and then this is my test at the end, the smell test. So it's not what you agree to. That's the most important thing you can take away from this is just because you say so does not make it so. Courts and administrative agencies use their own process to verify whether or not you have an independent contractor. And that's what these tests are. So let's get to the 5-factor test. Federal courts in particular use this 5-factor test. They want to know about the independent nature of the relationship. Is this person truly operating independently in their business, or are they dependent on the other company that's going to be providing them all the work, all the different opportunities for them to actually make a profit, move forward with their endeavor? So if you as the hiring person are going to really control this other person that you're hiring, that's not independent. That person is not likely to be an independent contractor. The next question is, what about the tools that are going to be used? Are the tools provided by the retaining company, or are they provided by the person doing the work? So when the person comes to cut your grass, are they an independent contractor? Well, they showed up with their own lawnmower, so they're more likely to be an independent contractor. Am I, as an attorney, going to be an independent contractor advising a client or an employee? Well, I've got my own computer, I have my own office, I am providing all the tools for my work. Versus if you go to work somewhere, there's a computer, there's a desk, they provide the internet access. They aren't providing the tools, that is more likely an employee. The third is the right to control. What that means is, if I give instructions, are you obligated to follow them, and to what extent? And how far down do we drill? So, for example, my clients give me a certain amount of instructions. I am legally and ethically obligated to follow their instructions to a certain extent, but not entirely. So if the client says that I want you to make this argument, and I disagree that that argument holds any water in court, I am actually bound to not make an argument that I do not genuinely believe applies in that case. And so I've got to use my own independent judgment. And so they can't direct and control and basically say, you must do as I ask. Versus, again, if you're an employee and the boss comes in and says, hey, I want you to move this over there, and then I want you to move that over there, they're dictating how that works, and that's controlling. The next one is a tricky one, the time the worker is employed. And so courts typically looked at the beginning of the relationship. What was the intended duration? Because you might certainly be hired as an employee on Monday, and by Friday, the boss says this isn't working out and you get terminated, but you were an employee during that 5-day window. That is the way the system was supposed to work. And these 5 factors we're supposed to be looking at. Are you going to be employed on a going forward basis without any finite term? The Fifth Circuit, in a case that I actually litigated at the Fifth Circuit, decided to turn that around and said, well, how long were they actually employed if the person has left? That was never really part of the analysis. And it's quite difficult to make it part of the analysis because you're supposed to decide if they're an employee at the time of hiring, not at the time of firing. So you're not supposed to look back, but the Fifth Circuit has done that. And so we'll see if that trend continues. But the idea is if you're working full time, there's no expected end date, then you're looking at something that's more likely an employee. Last is the method of payment. If you're being paid by the job, right? So again, a customer comes in to me, client says, hey, I need a contract. I give them a rate for a contract. That's one thing. If you're being paid weekly, bi-weekly, you're being paid on an hourly basis, right? If that's how you're being paid, that starts to look more like an employee. Now, I say here, no single factor controls. That is very important. You might look at a particular situation and say, I'm going to get 3 out of 5. It doesn't work that way. You know, one factor, it's not 3 out of 5. It's truly based upon an overall view of the circumstances that the court uses, which unfortunately gives a lot of latitude to the court to adjust the analysis to come up with the conclusion that the court wants. And so what I tell my clients is, remember, when you pick independent contractor, you are taking it out of your hands and putting it into someone else's. People don't ever really contest that they were an employee. It's always contesting that they were an independent contractor. So keep that in mind. Now, the 20-factor test, I am not going to go through every single factor in detail, but you'll see that there is a very direct connection between the 20-factor test and the 5-factor test. So the Department of Labor created the 20-factor test, and then the states adopted it. The Department of Labor and the federal courts have moved to the 5-factor test, but most of the states still use the 20 factors, and that list has grown and changed over the years. And so what you're looking at, and that's the tricky part, if you hire someone in a state outside Texas, what are the rules going to be? And even if you hire someone in Texas, are you in state court or are you in federal court? So there are a number of factors to figure out whether or not you have an employee or an independent contractor, and one of them is just who is going to be the decision maker. So what I've done is I've actually grouped the 20 factors into the previous 5 factors because they really do relate. And so the 20 factors give you a way of assessing those same 5 factors, and it's helpful to see it that way. And so again, independent nature, they're looking at, are you providing training? All right, and the one thing it says integration into the services of this company's operations. If the company provides a very specific service, we are a law firm or we are a landscape business, in either case. If the person is providing those services, so I'm a lawyer working at a law firm, it is more likely to be an employee. I get on a riding mower and I cut grass on a golf course, and this company is landscaping and lawn care, then I am an employee. Versus I'm the accountant, And so the company does either legal work or provides IT services or lawn care, what have you, but I do the accounting. The accounting is not integrated into the services that this company is offering. So that's important. Again, services are rendered personally. Can you offload that? You've hired me as your lawyer, but I have other lawyers that work with me. Am I able to have them do the work? If I work for a law firm and I say to my boss, a partner in a law firm, hey boss, I'm going to take next week off. I know a lawyer, he'll show up for me. That's not going to work. And so you'll understand that I'm an employee in that situation. So these are the kinds of factors that the court looks to. And again, no single factor controls. It's not a tick off. And if we've got 20 factors, did you get at least 11 to go your way? It is all based upon this overall perspective. So that's the independent nature cluster of the 20 factors. The second cluster, tools and equipment. It very much matches what I said previously. Again, the one tricky one here, though, is significant investment. And I have to tell you that I have never seen a case where they really were able to articulate significant investment in a way that was helpful. And what I mean by that is, I'm a lawyer. In theory, if I have a significant investment in my work that I'm doing, then I can be an independent contractor. Well, I paid to go to law school. And so that is far more expensive than anything that the employer is going to provide in terms of a computer, even a cell phone or internet connection to do the work, and a desk in an office. None of that compares to the expense of going to law school. So how do we determine the investment in that particular work? I've never seen that done successfully where a court was able to say, this is what it means when there's significant investment, and we can draw a nice bright line. So that's a tricky one that it's in there and it gets considered, but it isn't something that I would say you need to really be able to say definitively, here's the dollar amount. It doesn't work that way. The next is the right to control category or cluster. And again, same idea, the ability to control the work. And profit and loss is huge in this analysis. One of the things to keep in mind is that an independent contractor is supposed to be able to lose money. If you go into business for yourself, you are in theory able to make mistakes and therefore actually not make a profit. So if there's no chance that the person could ever make a loss, sustain a loss in this work, the likelihood that they are an employee goes way up. All right, next group 4, the time the worker's employed. So this is one of those questions, right? Are the hours of work set? Did you say this is 9 to 5, Monday to Friday? Can the person work on weekends or work at night to catch up? Are they able to work for more than one organization? They can farm out their services to multiple people or companies. Is the relationship continuing? Are they going to be working for you indefinitely? These are the kinds of questions that are asked in this 20-factor test in that cluster number 4. Now, the 5th cluster here, method of payment, we talked about, are they paid by the hour, the week, the month? But one of the key questions is, how do they document their work? If they are an independent contractor, they might show up and say, here's the finished product, pay me the fee, and you don't need to know how I accomplished it, how much time I spent. That's one of those moments where, again, it's independent. How I did it is not of consequence. That I did it is what matters most. So how you pay is an important piece to that. So those are the 5 clusters associated with the 20-factor test. Just so you know, the clustering is something that I did. The courts and the administrative agencies don't do it, but I have found that it is incredibly helpful to be able to match those up and move forward in a way that gives you an understanding of how they work. Now, when we're done, it's going to be a smell test question. I'll just tell you. If it looks like a duck, right? If it quacks like a duck, it must be a duck. That's kind of the issue that you're dealing with. And so you'll find that the decision maker's own personal association with the kind of work and the industry has a lot to do with the decision that they're going to make. If they're very much aware of a particular industry and have an expectation that employees in that industry are always employees, that's going to matter. I had a case where I litigated up to the Court of Appeals where My client had nurses. The Texas Workforce Commission sent an examiner to take a look at my client's business. The examiner walked away and said, yes, you have independent contractors. The examiner went back to the office and the boss said, no, they're employees. The boss had never looked at the file, had never spoken to my client, but just knew that they must be employees. Sent the same examiner back out a second time with a directive, you will find that these are employees. And you're not shocked. Yes, the investigator found that they were employees the second time, and we litigated that case heavily. So we weren't even allowed, just to bring that up, we weren't even allowed to show bias in the decision-making process. The court essentially said, throw out whatever happened, I'm going to make my own decision from the top. So each time the decision maker changes, you're going to get potentially a new decision, and they're going to bring their own bias to that process. So the last thing on the screen is assume each person is an employee. That is such an important step. Do not walk into the door and assume independent contractor and then look to see if someone can convince you otherwise. I would start with the expectation that someone you're bringing on board is an employee, and then be forced to justify why they are not. And that's an important consideration. So don't ignore that, don't skip over that. All right, so next up, contracts and handbooks. So I say that they might be worth the paper they're printed on. Let's take a look at what really you're talking about and what you're getting out of a contract versus out of a handbook. First of all, if you must choose one or the other between those two, I don't have a lot of money, but I need to figure out what I'm going to do to hire this first person. Should I get a contract or should I get a handbook? By all means, pick contract over handbook for your first employee. Basically, they're more enforceable. You're going to have the opportunity to put into a contract some protections for your business that are not available by just simply having a handbook. It is far better to be in a contract. And then you're going to limit your liability in certain cases. But then also, if you're planning to have an independent contractor, especially, there are certain key terms that I would want to put into this agreement that are going to be more helpful to you in the event you are challenged on the question of, is this person an independent contractor or are they an employee? So giving them a handbook doesn't help you as much on these key areas. So if you're only going to do one, that's what I would do. Now, be careful, because I have had more than one situation where someone showed up in my office and they said I had an employment agreement. And I say, great, let me take a look at it. And it takes about 5 seconds for me to say, this came from the internet. That worries me tremendously. Number one, whoever wrote this agreement, you are not sure is a lawyer. Number two, you are not sure that they met the standard of law in the jurisdiction where you are actually going to be working. So if you get a Pennsylvania or California contract, that is not going to necessarily contain what you need for a Texas-based employment contract. So I highly recommend that you spend some time with a lawyer in the jurisdiction where you're going to hire this person in order to make sure that you've got something that's truly enforceable where they are. Now, if you're able to do both, that's fantastic. I certainly would recommend that you try to do that if you can. I asked this question at the top: when was the last time someone read the entire employee handbook? I have clients that I have either drafted or revised their employee handbook over the years, and then I'll get a phone call at some time after that, and they will tell me about a situation, and then I will say, let's check the employee handbook. I think it's covered in there. And we go to the employee handbook. Sure enough, it's there, but the employer had no idea that it was in there. They're not reading it. And so I would say to you, if you're going to have the handbook, by all means, make sure you've reviewed it the first time you've implemented it. But at the same time, don't put it aside and say it's over. You've got this time period where things change, your expectations change, Maybe even the way you've decided to do things has changed, and the handbook might be outdated, or you might need to be reminded of some of the obligations that are important within your business that you set as an expectation on the front end. So don't put it aside and assume it's over. If you want your employees to read it, demonstrate the importance by you reading it. So that's an important piece there. One other thing to consider is what you put in the employee handbook. It could form the basis of a contract. And so I had this situation just last week. Person came to me with a problem at work. They had taken some steps based upon what was in the employee handbook, and the employer had certain obligations in the employee handbook once the employee moved through a process that was documented there. The employee did her part, the employer did not, and instead fired the employee. By doing that, they have actually created a breach of an implied contract claim in the jurisdiction where this person worked. That same kind of claim does not exist everywhere. So again, it's important what jurisdiction you're looking at, and that will determine a lot about how you handle certain situations from an employee handbook context. So what I want you to think about is it's not important for you to try to cover every single thing in your employee handbook. It is not your job to imagine the entire landscape of challenges and problems that you may encounter and then try to address them in an employee handbook. You shouldn't do that in a contract. My goodness, the contract would be the size of a phone book. And you shouldn't do it in an employee handbook either, because it's impossible. What you want to do is you want to outline the places where you are going to take certain kinds of steps and the factors you're going to use in assessing what steps you're going to take. So that could be a time off request. That could be a disciplinary moment. That could be whether or not you're going to allow employees to get loans. And so you don't necessarily want to cover the specifics. We will give a loan if you have worked here for at least a year, and that's not useful to you. You might say something like, employee loans are discouraged. In certain circumstances where an employee is granted a loan, they will be required to sign a document that confirms that their last paycheck can be deducted if they haven't paid it back, or something to that effect, and you could be done there. You don't want to get into too many specifics there. The other thing is, if you're hiring your first employee, just keep in mind that there are certain laws that do not yet apply to the size business that you have. There are certain laws that do. The moment you bring your first employee on board, certain laws will govern. And so you want to be careful not to put yourself in a position where you are over complying and putting obligations on your business that are not required. But, and this is why we review the contracts and why we review the handbooks periodically, client calls me and says, hey, it's been 3 years, should we take a look at it? Absolutely. And once we take a look, I start asking questions. How many employees do you have? Oh, we've grown to 19 employees. 1, there are certain things that don't apply. 19, there are certain things that do. We've got 60 employees now, 120 employees. Other rules apply. And so using the employee handbook as a living document that you're going to work through and refer back to on a regular basis is so important. And so I've said that several times because I cannot stress that enough. It is not a one and done, put it in a drawer scenario. You are absolutely better off putting this as a lead document. If you're going to spend the time on it, make sure that this document gets the treatment that brings value to the money that you spent to get this thing generated. Now, the next thing I want to talk to you about hiring your first employee is the non-compete and the non-solicit. And I got to tell you, I say it's not a matter of trust. This is the big mistake that business owners make. The first hire for your business is often someone you already knew before you created the business. Could be a relative, close friend, someone that you've kicked this idea around with over the period of time. And so you say, hey, can you help on this? And they say, sure, and they come on board. Now, you trust this person. You've known them maybe your entire life. And so why would you put them under the requirement that they sign a non-compete or non-solicit? The short answer is courts require that you first show an effort to protect your business before the court will then protect your business for you. What does that mean? Well, if you have employees who have access to information and they could leave and compete against your business, whether you trust them or not, the court will say, you haven't protected your idea, you haven't protected your business or your investment, and so I'm not going to protect you from competition because you aren't protecting yourself. So when you hire that first employee, note that I said a contract is far more important than the handbook. The first thing I want to put in that contract, even if you're hiring your mother, the first thing I want to do is make sure that your mother can't start up mom's version of your business, even though we have no expectation that she ever would. Because every employee after that, I want to have the same protections in place. And when the court says, are there any employees who do not have this non-compete or other protective measure in place, we get to look straight in the judge's eye and say, there's nobody that doesn't have this. Everyone that's worked here has this, all the way down to the owner's mom. So the rules of engagement on this. When you go into a non-compete and non-solicit scenario, I tell clients this can be bet the farm litigation. This is make or break existential threat kind of moment for a business if you're suing on a non-compete or a non-solicit. So if we're going to go to war, we need to have some rules of engagement on this. The first rule of engagement is Texas is a right to work state. It's a right to work state. That has no bearing on what we're talking about because the notion of right to work state is a labor union question. People use that term, they come into my office and they say, but Texas is a right to work state. And I say, that's true and irrelevant. So don't put yourself in the position where you're starting to try to make these arguments because when you do, any lawyer will understand you are basically using something that has no bearing and you've picked it up as part of the common conversation that we have. Texas is a right to work state, but that has nothing to do with non-competes, non-solicits, or any of that. That's number one rule of engagement. Number two, judges are people too. Why does that matter? Judges have an inherent desire for an outcome that they believe is fair. And their understanding of fairness is based upon whatever experience they come to the table relying on. So I've had judges say to me, well, this is America and we don't restrict people's freedoms. That's true, but also that's not the law that we're required to enforce. And so you've got to find a way to get a judge back to that. I've had a judge say to me, for example, well, I'm not going to enforce this because it seems to me that it's not fair. We've got to put the judge in the position of understanding how it's fair. And so don't underestimate the importance of having a document that is perceived to be fair by the judge. And how do you do that? Don't overreach. I've seen non-competes where the person is prohibited for 5 years from working in the United States. And you say, well, what was your job? Well, I sold IT services in the metropolitan area, Dallas Metroplex. Well, why can't this person sell in Austin, right? Or in San Francisco area? So don't overreach. The next thing is, if you're going to draft it, enforce it. Remember where I said judges are going to look to how much you've done to protect your own assets? This is the second piece to that. Okay, mom signed the non-compete. That's great. But Johnny over here left your business a year after that. And Johnny started up a competing firm. And because you and Johnny were kind of friendly, you let Johnny do it. You didn't bother him. And now that Susie wants to leave and start up a competing business, you want to enforce this against Susie? Not going to happen. A judge will look at that and say, you haven't taken the steps to protect it. Why am I going to take those steps to protect it for you? So that's very important. The last thing is protect your company's assets in more than one way. What does that mean? Well, let's start with the very basics of protection. The very basics of it are lock and key. If you have confidential information that is of vital importance to your business, do not leave it out. Do not have it readily available for people. If it's in paper form, have it in a locked file cabinet. If it's in electronic form, have it on a computer, but with limited access to those who have a need to know. That's important there. Next, have the contract. Next, enforce the contract. Then, if you've got documents, put confidential on it if it's a confidential document. Do things so that the court knows you've taken it seriously, and so now I will come behind you and take it just as seriously. So all those different things that I can show to a judge that you have done as a business owner are going to convince the judge that you genuinely value this information, you genuinely value the business and the company's assets, and I should respect that. That's only fair. So we're relying on that judge's notion of fairness in order to achieve an outcome, and you've got to be able to deliver when you step in front of the judge with these kinds of cases. Now, non-solicitation agreements vary depending on whether or not these are for customers or for your employees. And so let's talk about the customer dynamic first. Again, we're going into a battle on this thing if it comes up, so we need some rules of engagement for it. You really want to be able to say that you've got a customer list. Now, what is a customer list? The courts have said that customer lists that look like phone book entries, name, address, telephone number, maybe email address, that is not a protectable customer list. It needs more data than you could collect from the public domain. So, volume of their transactions, pricing that they pay, the extent to which you've got some kind of requirements in terms of performance. So if they say, I need this in this particular way, right, now you've got data on what this customer relationship looks like. And that is a customer list that has some meat to it. And a judge can look at that and say, this can't get out. But if you just have Mike Coles and a phone number or an email address, the judge says, Mike Coles' information is on the internet. You can just Google him and find this. Why am I going to protect someone from competing against you just because they know Mike's email? So that's the kind of thing you want to pay attention to. If you create a customer list, have that data that makes that list valuable. The next thing is document your pipeline. Now, if you're just planning a business, forget employees for the moment. Documenting your pipeline is a useful way of managing your business to begin. But by virtue of documenting your pipeline, the other thing you're able to do when we're talking about non-solicits of customers, you're able to verify for the court, here's the customers that we have, here's the customers that we have explicitly targeted, and here's the list of customers that we have sort of backburnered. We know that we're going to approach them, and they just haven't matured yet in terms of our efforts to reach out. The court is going to be very interested in protecting that universe of customers, not every customer that ever might have been one potentially. So be very conscious of documenting that pipeline. It helps your business, but it also helps me if I'm working with you to protect your customer base. Now, I've seen some non-solicit agreements and they didn't quite get to the end of the road. They say things like, you may not solicit a customer, and that's great. Let me tell you, customers call people that they know. And often your employee has such a good relationship that customers will reach out on LinkedIn, Facebook. Perhaps they have your employee's phone number. And so the customer is going to initiate that conversation. Is that solicitation? And courts have said, no, actually, they didn't solicit that work. That work came to find them. And so you want to basically have a restriction that says you can't go out and seek it, but even if it lands at your feet, you cannot accept it. And that's better protection for you. It also avoids you having to show how the relationship was formed. Did they solicit it or did it land at their feet? You don't care. They're not able to accept it in either way. But if you're going to add a non-solicitation agreement, I really want you to step back and think about this for a moment. If your customer said, I want to go with John or Jane, would you really restrict them? Okay, that is an important question. I have had many clients come to me with a non-solicitation agreement where they wanted to prevent an employee that had just recently left the business. They wanted to prevent them from accepting new customers that were the employer's current customers. And so I say right out of the gate, okay, I can race down to the courthouse and get this in front of a judge and get an injunction in theory against this person from accepting these customers. Understand that you are then going to be telling the customer they may not use the vendor. I am cautioning you that when you approach a lawyer to enforce that agreement, be prepared to have that candid conversation and let that inform your posture, including how you value a potential settlement. So when you're looking at settling with your former employee, perhaps, document that though. Do not just walk away from it because, again, down the road, you want to be able to show the court that you enforced it. And so I threatened this former employee and he or she signed some kind of settlement agreement and we resolved the dispute in such a way that I am still protecting my assets. The court will look favorably upon that. So just because you don't intend to enforce it, that does not mean don't have one. And just because you are not enforcing it in the moment, that does not mean walk away. There are steps to take to make sure that you do it correctly. Now, what about soliciting employees? This one's the tricky one. The rules of engagement here are a lot more difficult because you don't know when these conversations are taking place as the employer. They are happening quietly after work hours, on weekends, at lunch. So you don't know. And what you're trying to figure out is, do I have someone in my company that is cherry picking, right? The cherry picker is devastating. And here's what a cherry picker does. Cherry picker is a manager usually. Could be a lower level employee, but it's often a manager. And that person knows this is a good employee, that is not a good employee. This person has great sales with a customer that has a tremendous volume. This person has nickel and dime customers. I don't really need that volume to start my business. So the cherry picker looks around and says, here's the person I want to take with me. Now, I'll tell you just as a side note, the practice of law is very much this way. You have these large law firms and you have partners or members, shareholders, what have you, that are these people that are managers within the firm. And the person is then going to leave that firm and perhaps start their own law firm or move to a different law firm. And this person will cherry pick. They will say, I have these customers know this associate does good work. This associate is actually an up and coming associate with a good book of business. These are the people that I'm going to go and talk to about joining me at my other firm. And I have seen small and large law firms crater when a cherry picker is successful. if you get a cherry picker in your business, you're in trouble. And I'll just say that straightforward. You have got to be careful. How do you know a cherry picker when you see one? You really won't ever be sure, but the cherry picker is very much into data, right? And data is great for running a business. So you want someone that's very much into your data. But as you see relationships forming, I will tell you, make sure that you are getting some cross training. Don't have customers beholden to one employee, because that's the cherry picker's perfect scenario. So having other employees within the operation, having a relationship, you at a small size of an outfit should have a relationship with your customers to be able to manage that. That's how you undermine the cherry picker if they're going to leave and try to take people with them. One of the questions I ask, can two employees mutually solicit each other? We went to lunch together and we were just talking and we were kind of having a gripe session. And one of us said, man, we should go out and start our own business. And the other person said, yeah, you're right. And that was the day that the business was formed, and that's how it happened. So neither one of us solicited the other. You can't stop that, okay? That's not gonna be something you can prevent. But once they had that conversation, if one or the other or both, go to the next person and say, hey, we're gonna start this business and we're out of here in a month. Are you coming with us? You could perhaps then stop that. The other thing is, you might find, and this is something that happens a lot for people who are starting a new business in an industry where they have experience and they are leaving an established firm to do it. So perhaps this is you today starting your own business and you are leaving an entity, and as you leave, they basically say, look, I know you're taking one other person with you, but we'll let you do that. Let's have an agreement between us that you'll take no one else from our company, and we won't take anyone from you. Or alternatively, let's say a few years down the road, you're in the position of being the established player, and you want to say, look, don't take anyone from me to this employee who's leaving, and I won't take anyone from you. Is that acceptable? I will tell you that it has proven to not work in a number of cases. So be careful in terms of putting that, instead of in the agreement with the employee, putting that in the agreement with the potential future employer. I do not recommend that you do that. Jurisdiction by jurisdiction, you're going to start running into problems. Now, last practical question, right? I ask this about customers, I'll ask it about employees. Do you want an employee that does not want to stay? The short answer is typically not. That does not mean these agreements aren't useful. It just means where the person leaves, all you want to do is restrict them from going into a business with someone else or taking someone else out, right? That's what you're looking to do. I'll give you an example. In Texas, if you're a teacher, for example, you sign a contract, and that contract is for a year. If you don't finish that contract, you can't necessarily go and use your certificate as a teacher to work in a different school district. So they can report you to the board, and they can essentially prevent you from using your certificate to teach elsewhere in the state of Texas. The idea behind that is, if you don't want to stay and teach, by all means, we do not want you in front of a classroom of impressionable young minds. Let's get you out of that space. But we're not going to let you go somewhere else and teach instead. So that's the theory behind it. You don't have to stay, but you can't use these skills anywhere else. And so that's the idea. You can't, if you want to try to steal my employee, I am not going to let you do that. The employee can leave of his or her own free will, but they can't go join you after that. All right, so there's your protection of ideas. And our last topic, we've got about 15 minutes, so we're cruising on track. We've got some things to cover in terms of what are you trying to do when you're actually bringing on employees. There are some must-haves, some nice-to-haves, and then there are things that are a waste of time. And I will talk about those wastes of time, because It never ceases to amaze me how much time I have to spend with clients walking them off that ledge that they wanted to jump off with some idea they've got that they think is great. And I'm trying to explain to them, this is a waste of time. So I'll cover the must-haves first. The truly must-have. If you get audited, if you get in a lawsuit, if someone gets a personnel file out of your office and they look to see what you've got, I need 4 things documented there, no matter what else you do. I need your I-9. The I-9, if you don't know, that's the document most of us, if not all of us, have executed in some way, where you show up. Most people provide a driver's license and a social security card. You sign off on it that you're legally authorized to work in the United States, and you move on. First of all, do not insist on any particular document. Don't say, I need your driver's license and social security card. It is not permissible to require a specific set of documents. There's a list, and they can provide anything on the list that qualifies. So let them do that. That's the first thing. Second thing, you got to have that W-4. That's showing that you're going to tax them and how. All of that stuff is calculated based upon the information that you collect on the W-4. This third one, I have to tell you, it's such a frequently missed item. You are required by Texas law to report to the Office of Child Support with the Attorney General's office. You are required to report every new hire in Texas. That's done for child support withholding, but it is also done so that people who are receiving unemployment today don't continue to receive it after they have a job. And yes, there's no surprise there that people who are receiving unemployment but finally get a job will continue to get checks for unemployment for some period of time, and they will not say anything about it. So absolutely, you are required by law to make that report. The last truly must-have, if in your business you are going to do background checks, and I've certainly recommended for a lot of businesses, anybody that's got cash handling or contact with customers outside of a traditional retail location, so if they're going into customers' homes or anything like that, a background check is so important. But before you do that, you better have your Fair Credit Reporting Act paperwork ready to go, because you cannot conduct a background check unless you have actually gotten their signed permission. And if you do the background check and you find something that leads you to take an adverse action, like rescind a job offer, you must provide them a copy of that. So I need those 4 things no matter what in that file. Failing to do any of those is an independent legal violation. Now, not really a must-have, but it's pretty close. I really want to see in that file some signed agreement that protects your company. I really want to see the payment terms in writing somehow. And I sure better see a document if there's any expectation of ownership in the future of the business or ideas. Especially in a new business, what happens is you bring on an employee, you've got a business that's essentially at its very infancy. Now, this person comes along and says, hey, I know we're doing X, but what about either changing it to Y or adding Y on, but making some change? Who owns that idea? In a new business, that is something that has to be captured and documented, because new businesses are going to potentially have a leg kicked out from under them if they're relying on some piece that was brought to the table by an employee, only to find they don't own that as a business. The employee can take that with them if they leave. So don't have the leg kicked out from under you by failing to have it documented who owns what. And similarly, if you're going to give them a share of the business in the future, document it, even if you're just documenting that you'll have the conversation in the future. Because people will say, you said I was going to get 10% of this business. You wanted to say, after 2 years, we will discuss ownership of the business, some percentage. Now, couple of things that nice to have. You'll be glad you had an employment agreement. I guarantee it. If you start from that as an initial document with all your employees, you're going to be glad you did it. Job descriptions. You really need job descriptions to be able to delineate who is doing what, and to use that to basically check the resume and the skills of the people you hire. Job descriptions are not just to tell you what to do as the employee, they are to tell me what to look for as the hiring person. Workers' comp compliance docs. Are you a non-subscriber? Texas, shock, only state in America that has non-subscriber provided. And what is a non-subscriber? That means that you do not have an insurance policy. So I'm going to pick up this question that was just asked here in the Q&A. The best way to give an invaluable employee a share of the distributions or profits without diluting. That is a great question. Let me just answer that by saying you can use a bonus program. That is easy, often done, very common. It's also a possibility to give a sort of a distribution through some phantom stock. And you can even make the phantom stock convertible into real stock over time. So those are two ways that you can do it. You got to be careful that you don't create an obligation to actually do something that you didn't intend. But those two things, bonuses at the end of the year or quarterly, and also phantom stock that give them a participation and also allow you to convert them in the event of selling the business down the road. So let me jump back to the workers' comp. Texas, non-subscriber. One of the key questions then is, are you going to get workers' comp insurance in Texas or not? If you do not, you've got to make sure that the employees are aware of that. And you are required to report injuries at work to the state. So be sure that you've got your documents ready for that. Don't go looking for it once the injury occurs. Have that ready to go. The last thing is your payroll and payroll tax compliance program. Who is doing that? Do you have an accountant, a bookkeeper? Do you have a payroll provider? You know, there's Paychex and ADP and all these companies. So have that in place, ready to go when you hire the first person, and know how those things will be done. All right, our last slide before we wrap up here this morning. Wastes of time. I say rethink your business model. If you're coming to me as a client and you say, here's something that's really important to me, and I want to get this done for my employees, the vacation policy. I tell my clients, big and small, listen, you don't want a separate vacation policy and a sick leave policy, and you've got employees that are basically having to lie about why they're not there. If that employee is going to not be there, just look, you got 10 days. I don't care if you want to take it as a sick day, if you want to go visit your family, or if you just need a mental break holiday. I don't care. It's 10 days. That's a far more useful process. Another one, zero tolerance policy. Tough guy employer comes to me and says, I want to make sure that people know if they do X or Y or Z, they're going to get fired. And I say, if it's that bad, it will be obvious that you have the right to terminate. Why put yourself in a position where you've taken away the right to terminate and you've made it an obligation? Because the first time you don't want to do it, what have you done? You've created a process where now you're potentially discriminatory in your application of this zero tolerance policy. So terminable offenses can be identified, but zero tolerance policies are not a good idea. Waivers of liability. I've had clients come to me and say, hey, I want people to sign off when they start work that I'm not going to get sued by them. That does not work. That is absolutely not useful. Don't bother with it. You're only going to make yourself look worse than you may actually be. So be very comfortable that you're not going to get that done. And then my last one, and this one needs its own moment here. Circumventing the overtime laws is such a big problem. Whether you're using an independent contractor agreement or you want to pay people on a salary basis, but you don't want to pay overtime is the point. This is an area of law where people literally have law firms that just sue on overtime. I have seen thousands and thousands of dollars spent on overtime payments in litigation because someone tried to duck the overtime process on the front end. It cannot be done. It is the single most employee statute on the books in America, overtime. So that with minimum wage together, nothing is more employee friendly than that. So if you're going to hire an employee and you think, how do I get away without paying overtime? What you're really asking is, how do I defer payment of overtime and then pay double later, because the court can make you pay double. So that's what you're asking me. How do I avoid paying overtime? I say, you really are asking, how do you pay double later? So that is my presentation. If there are any questions, I'd be happy to answer those, but I appreciate your time and attention this morning.